Good morning, everyone. Welcome to the Northeast Transition Collaborative Network. My name is Matthew Atea. I'm the Director of Guided Personal Supports and Community Resources at Northeast ARC. Today's topic is guardianship and alternative models, decision-making with your loved one in mind. We have two presenters joining us today from Disability Law Center. Please welcome Hillary Dunn Stanis, Senior Attorney, and Laura Sousa Wagner, Staff Attorney. Before we begin, we'd like to share some information about our network. The Northeast Transition Collaborative Network has grown to over 950 participants, including educators and caregivers. These sessions are designed to foster collaboration and provide practical strategies to support students and families during the transition process. The Northeast Transition Collaborative Network was created by the Community Resource Center at Northeast ARC to bridge gaps in communication between schools, agencies, families, and community partners. We host monthly webinars and quarterly in-person professional development sessions to unify resources and to strengthen person-centered transition planning. The Northeast Transition Collaborative Network is now an approved professional development provider through the Massachusetts Department of Elementary and Secondary Education. This means educators who attend our professional development sessions can earn PDPs towards their license renewal. We're excited to offer these high-quality practical trainings that support educators in empowering students during the transition process. At this time, I'm now going to hand it over to our presenters to begin today's session. Hillary and Laura, please share your screen when you're ready.
Okay, does that look as it should, Matt?
Yep.
Okay. Or at least I'll speak for myself. I'm a lawyer. I'm certainly very tech challenged, but so all right, glad it's looking good. So thanks for having us here and thanks for joining everybody. As Matt said, Laura and I work at the Disability Law Center. And I'll let Laura just say hi and welcome folks herself.
Hi, everyone. My name is Laura. As Matt said, I'm a staff attorney at the Disability Law Center, working very closely with Hillary in the IDD space. We hope you enjoy our presentation.
Thanks, Laura. So the Disability Law Center, in case folks don't know, just very, very quickly, and we're happy to answer more questions about DLC, Disability Law Center at the end, but we're a private nonprofit that offers free legal services for folks with disabilities. We work in the area of disability rights. And just a giant caveat with all of that is, we do the best we can to serve as many people as we can, but as you can imagine, there's a huge demand for our services and our help. So a lot of our work ends up, we do some individual representation, but we try to really focus a lot of resources on systemic work that really can impact lots of people within our state's community, within the disability community. So again, if people have more questions, happy to talk about it at the end, but we have a lot of information to get through, so we're going to jump in. Oops, why are we not? There we go. So for the folks that are getting their some professional development credits or whatnot, these are the learning objectives for today. I'm not going to read them all. You can see them and you will be getting a copy of the slides and whatnot after this presentation. Our basic agenda for today, why are we here? What happens when someone turns 18 from a legal standpoint, or just is over 18 from a legal standpoint, some issues around decision making. And we'll start with talking about alternatives to guardianship. And then Laura will take over and walk you through some information about guardianship, and we'll take some questions and all of that at the end. So that's our general flow. Okay, so this is why, kind of 18 is a big deal. I'm guessing a lot of people already know that, but just, kind of quickly, a big thing. You turn 18 from a legal standpoint, in the eyes of the law, you are a adult, a legal adult, meaning all decision-making responsibilities, rights, responsibilities are with the adult, just like with anybody else when they turn 18. So no matter how significant the disability is, a person is legally considered an adult, legally emancipated when they're turning 18. The law presumes competence, which is a good thing, right? It presumes people are competent. So if we're talking about whether it's a student or your child or somebody, that you're working with in some other capacity outside of school or family, if it's somebody that has a disability that may affect their decision-making abilities and they're approaching 18, we really should be starting to think through, where they may need help and what are the options available. Of course, many people with disabilities, they don't need any more assistance making decisions than I do, or things of that nature. So certainly somebody could be independent and not need anything, but there are folks who might need some support making those choices, and we're going to just talk about some of those. All right. There is nothing magical about this list here, this slide. It's just supposed to kind of keep us thinking through what are areas that as adults we have to make informed decisions in big, large buckets in our life. These are some big important areas that as adults we have to be making decisions every day, and they need to make sure they're as informed as possible. So if a person is needing some assistance with making decisions in all of these areas, one of these areas, a few, whatever, we just need to assess, what the needs are. How can we meet those needs? What's already available to meet those needs, and kind of what assistance really is needed. So now we jump to, we've identified that assistance and decision making in some amount is needed, and this really inartfully done graphic they did probably a decade ago and could use some, spicing up from a visual standpoint. It's just meant to depict the idea of that many of us, if we're either in the school system or have a child in the school system or just are familiar at all, the idea of like least restrictive to most restrictive, right? So on the left, we're kind of starting with our lesser restrictive options to support somebody who needs some amount of assistance with decision making. As we move to the right, they're more restrictive. This is a very inexact type of graphic. It's just trying to get you to think in this less restrictive to more restrictive, because really the more restrictive ones are essentially limited guardianship, conservatorship, full guardianship, right? So the ones on the right, those would be the most restrictive. And as in kind of the special education world, that isn't, it's not a dirty word that they're more restrictive. It just is what it is. And we have to think about somebody's needs and not automatically jump to the most restrictive, and think through what are some of these other less restrictive options available. It's best practice, but it's also what the Massachusetts law requires us to do. So I'm going to march through some of these different alternative options, but I do just want to make sure that we're all kind of operating from the same standpoint of understanding what we mean when we say guardianship. And Laura is going to go into a lot more detail, but just when we're talking about guardianship, we are talking about surrogate decision making, right? Removing it from the individual with disabilities and from any individual and giving it to somebody else. So that is removing it, completely, whether it's a full guardianship or limited in some capacity. We're removing some of those decision making, medical decision making, healthcare, giving it to somebody else to make those choices. Just want to kind of make sure that we're clear that that is what we mean when we talk about guardianship. You have to go to court for guardianship. It's a formal process. Many decades ago, we would say guardian of the person and guardian of the state. Conservator is what formerly would have been known as guardian of the state. And a conservator, just so people understand, is kind of really only necessary if somebody lacks the ability to make informed financial decisions, but also that they have, income, assets, property other than government benefits like SSI or SSDI. So for a lot of, unfortunately, a lot of folks with disabilities, right, they're struggling to get employment or things of that nature. So if their only kind of income is SSI or SSDI, you don't need to necessarily be concerned about a conservator. That's if there's a lot of other assets, money, things of that nature. So why, I put negatives in quotes, right? Because sure, there are negatives to guardianship. At the same time, there are there are instances in which guardianships are sometimes necessary. So we don't want it to be a dirty word, a negative word. But if it can be avoided, there are certainly reasons that we may want to avoid moving all the way to the restrictive option of guardianship. In many situations, there are, the alternatives that we talk about might be able to really provide the level of decision-making support that is really needed for the person. So, if we're talking about guardianship and removing that decision-making authority, it really kind of eviscerates self-determination, right? There's been a legal determination that somebody's incompetent in certain areas or like just in generally in areas. So it kind of has a really negative impact on self-determination. It is something you have to go to court for. It's public, this isn't a private matter. You have to be in a busy courtroom doing this. Some people feel like they need to hire an attorney to do it. Some people don't, but that can just be a little tricky to figure out for folks. And again, the laws in Massachusetts really, they require us to be exploring the less restrictive alternatives first. And if a guardianship is needed, it's to think through how that can be as limited as possible, meaning the individual disability retains the most rights and responsibilities as possible. So for folks who work in schools or have teenagers or young adults, they hopefully maybe are familiar with this already. So one, we're jumping in to talk about the different alternatives to guardianship. And something really important to keep in mind is typically if somebody does need some amount of support in decision making and we're using some of the alternatives, there's a bunch of used together. It's not necessarily that you just use one and that's it. You can very easily combine and utilize a number of these to ensure that somebody has support in various different areas of their life. So here for the educational decision-making authority, this is, regarding their special education rights, that when a student turns 18, the decision making about their IEP, what to accept, what to reject, placement acceptance, reject, all of that goes to the student, right? So it shifts at 18 because they're legally an adult, goes to the student unless somebody does something, basically. And two things could happen here. Either the student can share their decision-making authority or delegate decision-making authority. And I'm actually going to say those are one thing, even though they are technically two separate things, but they can either share or delegate their decision-making authority. Or if we're in a situation where somebody has really, really significant disabilities and we really are feeling that guardianship is what's going to be necessary for this person, then you don't need to worry about this because if you have guardianship, you don't have to the person doesn't have to delegate their decision-making authority to you because a court has already done that in a very formal legal fashion. So if there's going to be a guardianship in the picture, you don't have to worry about this educational decision-making authority, just to be clear. But if we're trying to think through other alternatives, then this is one where perhaps the student shares decision-making authority with a parent, caregiver, whatever, or perhaps they delegate that decision-making authority completely. Important to remember that the student can revoke the shared or delegated authority at any time. Okay, I'd like to spend a little bit of time now on supported decision-making, which is another alternative to guardianship. In more recent years, although it's been a long time, over a decade now, um, and really kind of 2 decades across the United States, I'd say over the last 2 decades, supported decision making as an alternative to guardianship has really gained traction. It's kind of the sexy thing to talk about in some ways, and it's an alternative to guardianship that again is very frequent. When it is used, it's very frequently used in combination with some of the other alternatives, like representative payee, like healthcare proxy, or the shared decision making in an educational context, or delegated, right? So again, you can combine many of these together to support people in various different areas across their life. So what is supported decision making? Just really basic concepts here is we're talking about supporting a person in making decisions, so they are keeping their legal rights and their responsibilities to make decisions. We're not taking that and giving it to somebody else. So it's not a substitute making decisions for them. It is the individual retaining their rights and making decisions about their life. They just with a designated support person or people providing some support along the way in designated areas. So these designated support people are chosen by the person with a disability. They are not just imposed upon them. Typically, it has been, family members, friends, or other, community members that are important in the person's life. The support people, in terms of kind of building in safeguards here to ensure there's no abuse, no conflict of interest, no undue influence, right? So choosing the support people and making sure they really are of the individual's choosing is a really important step here. And the person with a disability can at any time kind of change a support person, kick one to the curb and add a different one, right? This is a flexible alternative to guardianship, and it's meant to be informal, formal, kind of all at the same time. This is not court sanctioned, meaning you typically don't have to go to court related to supported decision making. This is something that is done outside of a court. And I guess a big thing to think about here is taking the step back and thinking about, we all do this, right? But people with disabilities, when they do this, we, have to put a label on it. But we all do this in every day. We all have our network of friends, families, acquaintances, professional connections, whatever it is that we reach out to when we need support or guidance, right? Like, I'm not going to just go buy a house, change a job, have a really major surgery, something like that, without talking to anybody. So we are all doing this, having this circle of support. This is just a slightly more structured format of the same idea and concept. So there are typically written agreements that we call supported decision-making agreements, and I'm just going to say SDM because it's much shorter. And these written agreements, they spell out the specific areas of needed support, and they designate which chosen support person or persons will help with that. So maybe it's financial choices, maybe it's healthcare choices, right? And there's a designated support person or more than one person who helps support the person in making an informed decision on their own. Supporters also sign this agreement, which would make very clear their role is to support, not make the decision for the person. And when we talk about support, right, that could be helping somebody understand the consequences of certain choices. It could be making sure that the information is presented in concrete, plain, understandable layperson language, right? Not medical mumbo jumbo that is really difficult for all of us to understand, right? There's different ways we can support folks in making choices. Obviously, this is going to promote self-advocacy, self-determination, and the most independence possible for an individual. So that's some of the basics of supported decision making. Now, do want to kind of just quickly go through where things stand in the United States and where things stand in Massachusetts with kind of what's happening with SDM. Like I had, this slide is just to really show that it's maybe just gaining traction in the last decade plus in Massachusetts, but there's been some pretty major things happening in the US for some time now, both in court in terms of folks where somebody is seeking guardianship or they are under guardianship, and courts have determined that as in that individual situation, based on that clinical support, that a supported decision making arrangement and agreement is sufficient and appropriate for that person, as opposed to a more restrictive like guardianship situation. So that's what the, just to illustrate what some of the cases out there have shown. Now, from legislation, there are 20 states in the US that already have laws on their books that, really formalize and provide authority for supported decision making and agreements of the same. Massachusetts is not one of those states. We like to think we're so progressive and all of that. And, I'll just say Texas has had a law on the books for over a decade, and Massachusetts still does not. So it is something that's fairly widespread in the US, and we are kind of not really at the forefront of that. And, that, I don't know. It's just sometimes we think we're very progressive on disability policy. Here's an example where I think, people who are supporting the alternatives, we're kind of hoping things move along a little bit quicker. And just the national support, some major organizations that do support, of course, in appropriate situations, that SDM is a viable alternative to guardianship for folks that are able to be making such choices on their own with supports. In Massachusetts, like I said, we don't have a law on the books yet. There's been a pilot project back in 2014, which when people during question answer, if people have a lot of questions about kind of how that came to be, what the results were, I'm happy to talk about it. But it was in Massachusetts, mostly done in Western Massachusetts, with about 10 individuals with intellectual and developmental disabilities, and their families or caregivers were supportive of kind of exploring SDM as an alternative to guardianship. And there were some very overall positive outcomes for those folks. And in one of the cases, it resulted in a court agreeing to terminate a guardianship in favor of the supported decision-making arrangement. So that was a big deal for Massachusetts. There is a large coalition of many legal services and other disability advocacy organizations and individuals called the Massachusetts Supported Decision-Making Coalition. I almost said collaborative. So that's what that MASDMC stands for. So that coalition has a lot of members, a lot of support, and that coalition is the group that has kind of really pushed and supported getting legislation passed in Massachusetts to make sure we have a law on the books that recognizes supported decision making in a more formal capacity. So I'm not going to read all these bullet points, but these are some of the highlights of the bill that was proposed in the 2025 legislative cycle. There was a bill in the last legislative cycle that was essentially the same that did not pass. We're hoping it might pass now. I will say there's been a lot of back and forth about some of the language in the bill, so we still really don't know if it's going to pass or not. And particularly around this last bullet point, at present it is not clear that if it were to pass, that what is in that last bullet point would possibly not be in the version that right now some legislators would prefer to pass. So all this to say there's a lot of moving parts right now. And if you want Mass to have a law on the books, call your legislators, let them know that you would like it to pass as a viable alternative that should be explored before somebody is put under guardianship. So these are just some resources. Again, you're all going to get a copy of these slides, so you can go to these different, the first two are wonderful sources of information of like the history, how it works, blank templates of written agreements. It's wonderful. And there's some of that on the Mass Advocate Standing Strong. But Mass Advocate Standing Strong, for folks who don't know, is a self-advocate group of folks with intellectual and developmental disabilities. And I would really encourage anybody who's considering supported decision making to hear from self-advocates. So some of the self-advocates from this group do presentations, sit on panels, things like that. And people, self-advocates not affiliated with that group do the same. And I think, folks that are doing this in practice are the best people to learn really the ins and outs of how it's going, what's working and what's not working. But yeah, if there's more questions, and I'm sure there might be, we're happy to talk about that more in the Q&A at the end. But we'll just move on to some of the other alternatives before we turn it over to talk a little bit more about guardianship. So another alternative to guardianship that oftentimes is very rarely used by itself, as opposed to, again, with other ones, is getting a representative payee. So this would be appointed through the Social Security Administration when the beneficiary, the person that's getting SSI or SSDI, when they're unable to manage the funds from that in an informed, capable way. So this is appointed through Social Security. This isn't through the court, and this isn't just kind of like a form you can do on your own, right? This is through Social Security is how you have to do it. And important to keep in mind that if somebody is serving in the capacity as a representative payee, they don't manage all of the individual's finances. And beneficiary is the Social Security term. That's why I'm using it. So that if you did contact Social Security, they would probably be using the term beneficiary to talk about. Here, we're talking about the person with a disability. But important to remember, a rep payee just manages the SSDI or SSI. They are not managing all the finances of the individual. If a person has a whole bunch of finances, property or assets, right, that's where we might need to think about the conservatorship piece that I referenced at the beginning. But in many, many situations, a representative payee could be sufficient to address concerns around finances if the main source of income or assets the person has is SSI or SSTI. Okay, and the last two alternatives that I'm going to talk about are a healthcare proxy and a durable power of attorney. These are no different than the healthcare proxy and durable power of attorney or other types of power of attorneys that many of us already have in place or probably should have in place ourselves, right? These are tools that everybody should be thinking about. But in the context of folks with disabilities who might need or who we really think do need some extra support, but that they are still capable of making healthcare types of decisions, a healthcare proxy can be something that is helpful as part of kind of this like package of supports that are alternatives to guardianship. So for the healthcare proxy, I think what's really important to keep in mind is, again, it's the same document that, I have a healthcare proxy where it designates my husband as my healthcare agent, right? That's who I appointed. But just like in my situation, the healthcare agent does not make decisions for the person unless and until that person becomes incapacitated. So this is not, a healthcare proxy does not mean, oh, okay, my person or the student or whatever executes a healthcare proxy and now I make all their healthcare decisions, right? That would be a guardianship type of thing, right? Removing the medical decision making and giving it to a different decision maker than the person. This is just if the person becomes incapacitated, then the healthcare agent is making the decisions for the individual. There's advantages, of course, here that it can be completed without going to court. But really, the big piece here is the person has to have capacity to execute this document. And that means two things. They have to be 18 or over, because legally that's when you're an adult. But they also do have to have capacities. A lot of times we think of it as like capacity to execute a contract type of a thing. So generally, they have to understand what it is that they're signing, understand that it's a legal document, kind of the nature of it and the effect of what they're signing, and what they're appointing the other person to do. They have to understand, right, that who they're giving this authority to, this power to, and they have to be doing it voluntarily, right? This is a willing choice they're making, not doing it under undue influence. So somebody does not have to have the capacity, the ability to read a blank healthcare proxy, the template, and understand what every single word in there means. I would venture to guess that all of us don't understand every single word in a healthcare proxy. So that is why I just want to emphasize it means that somebody understands really kind of like the nature and the effect of what they're signing, and that it's a legal document. They're not going to court for it, but this is an important legal document, and that you're giving power to somebody else that you've chosen to make some healthcare decisions for you if for some reason you're totally, unable to do that at a certain point. That's it. But there are people where, there is a question of capacity. Are they really able to execute this healthcare proxy? And that's something that, we just need to be thinking about and consulting clinicians as needed. It is revocable. I think anybody can revoke or change their healthcare proxy. Sorry, wanted to make sure I mentioned one more thing about the healthcare proxy is an area of concern for, I would say, a lot of parents or family members in particular around healthcare, doctor's appointments, all of that, is access to the doctor, access to medical records, right? That my person is going to turn 18, or maybe they already are 18, and I do think, they need some support with this. Yes, we're going to do the healthcare proxy, or there is already one in place. That's great. But the healthcare proxy doesn't give you access to medical records. It shouldn't. I think some places are perhaps a little more lax than others. It shouldn't give you access to that. You shouldn't be able to pick up the phone and call the doctor and get all the medical information. Like, that's not really what a healthcare proxy should legally be able to do. However, all that would have to be put in place for you to have that access would be essentially a HIPAA compliant medical release, right? Like the same that many of us would use, if we have our parent is aging and we just want to be able to be helping out and have access to their information, right? They execute a HIPAA compliant medical release and we can have access to their medical records. We can call the doctor and ask questions, right? So this doesn't have to be a big complicated thing. It's just a medical release that a lot of us are already familiar with, can help you with that access. And finally, durable power of attorney. It's kind of the corollary, right? The sister to the healthcare proxy, because here you're just talking about the person's, financial affairs, in a sense, whether they have a bank account or something of that nature. Durable here just really, it means that the power that somebody is giving to their power of attorney that they're designating, it means that it's going to remain valid even if at some point in the future the person becomes incapacitated. So that if a question of capacity arises in the future, this would remain in effect, and the designated person would remain the designated power of attorney, be able to make those decisions. Again, this is, the person has to have capacity to do so. So they have to be 18 or over, have that capacity to execute this, understanding of what it is. This, again, it doesn't take away rights from the person with a disability. That doesn't take away decision-making rights here, but it does put a family member, you or trusted friend, whoever the person designates, it puts that person at the table, right, as part of the discussion. And again, it can be completed without involving the court, and it is revocable by the individual if there is a problem with the person that they've designated, not really abiding by the agreements and things of that nature. some just quick other options to think about as alternatives in supporting someone around kind of some financial issues. Of course, a trust can be established, a special needs trust, naming a person with disability as the beneficiary of that trust, and there could be a trustee managing the funds if that's something that is in your future to do. And you also, there can be a joint bank account too, right? Like we can do a joint bank account is a pretty easy option that a lot of people do. And I think I will stop there with the final statement just being those are all the alternatives to guardianship. Many people bundle them together. We are not in any way saying that a guardianship is never really perhaps necessary, and we never advocate for you to be trying alternatives to guardianship when that would create like a really unsafe, dangerous situation. That's not what we're advocating or really giving you information about. The point is just to be really thoughtful about, are there less restrictive options available for the person with a disability? Because there's so many people with disabilities who really just, they need some support. They don't need somebody else making their decisions in every area of their life. But let's, switch over now to talking about guardianship, and Laura, go for it.
Thanks, Hillary. Um, so if you've gone through and determined that none of these less restrictive alternatives would ideally work for, the individual, then we look to consider guardianship. And so I'm going to kind of walk you through what that process kind of looks like. As Hillary mentioned, this is a process that has to be completed in a court setting. So we're going to talk about what the judge looks at, kind of what elements need to be met in order to establish that guardianship, and what the ramifications are of the process and establishing that guardianship. So essentially the person, in order to be found, eligible to be placed under guardianship or that a guardianship is necessary, they have to have a clinically diagnosed condition that makes them unable to receive or evaluate information or to make or communicate decisions. And that inability has to be to such an extent that they are unable to essentially meet essential requirements for physical health, safety, or self-care. And that is even when, if they have an AAC device or any kind of, technological assistance with communicating, that would be even with that technological assistance, they're unable to kind of communicate, informed decisions regarding their health, safety, and self-care. And as Hillary already mentioned, this is assuming we've already kind of gone through and determined that none of those less restrictive alternatives are appropriate in order to meet this person's needs. The appointment standard for conservatorship is largely the same as Hillary mentioned. It just is geared more towards the decision making over someone's estate and their assets rather than, the person and kind of their day-to-day decisions. So under Mass law, it requires that a guardianship, if it's going to be established, to be as narrowly tailored as possible and is the least, again, restrictive alternative appropriate for the person. For example, this could be a guardianship that is limited to medical decision making only. But even if it is a plenary guardianship, there are still limits on the control and the power of the guardian. And when we're looking to ensure that this guardianship is narrowly tailored, we have to look at first what the individual's functional abilities actually are and what potential limitations there might be on those abilities. And in order to do so, there has to be a clinical evaluation. You need clinical support that kind of backs up their either capabilities or their lack of capacity and their competency. It isn't just about filing a petition, with the court asking the judge to essentially give the petitioner decision-making authority. There has to be support from a medical professional kind of backing up the reason why this guardianship is necessary. And this is important because, as we mentioned several times, you're essentially asking the judge to remove all decision making from this person and give someone else complete authority. I mean, it's a very big deal. So there's kind of this added extra step of having this clinical support and opinion that this is really, really necessary. So the way that this clinical support is established is one of two ways. There's either a medical certificate that has to be completed or a clinical team report that must be completed and submitted with the petition for guardianship. Um, and these help ensure not only support for the petition, but also to make sure that it is as narrowly tailored as possible. And courts do tend to rely heavily on these documents in the process for determination of capacity or incompetency. So the first form that we're going to talk about is the clinical team report, and this comes into play when we are talking about somebody who is subject to guardianship who has an intellectual disability. And this clinical team report has to be completed by three different professionals. Essentially, it has to have part of it completed by a physician, a licensed psychologist, and a social worker. And it must be dated within the first 6 months of the filing of the petition. And when these clinicians are filling out this form, they should review any previously completed assessments of the person. They need to interview or examine the individual, and also people who know the individual well. This form asks the clinicians to describe the person's diagnoses. It asks them to describe any current medications that they're on, factors that clinician believes will impede the person's current capacity for decision making. It asks them to describe what their social networks look like, any risk of harm that there is to themselves or others, and also areas in which the person is able to make informed decisions. This clinical team report has a section that is expected to describe, whether that's in the realm of health, self-care, safety. It does look to areas that this person is capable of making decisions for themselves. And then it asks for areas in which they are not, and also why, how these diagnoses specifically impact that person's ability to make these decisions. And lastly, it includes a section on whether the individual should be present at the hearing. They do have a right to be present at the hearing, but there is a section that the judge does tend to lean heavily on, where they do ask the clinician's opinion on whether this person should be at the hearing. Now, because all three of these professionals need to take part in this clinical team report, families should start thinking about, who might be appropriate to fill out this clinical team report before the person turns 18, or even 17 and a half, because sometimes it can take a long time, to find the appropriate clinician who is qualified and capable of, accurately filling out this form and who's willing to fill out the form. Sometimes people will look to the school, whether the school psychologist might be willing or able or know somebody, or the social worker. And also transition specialists should be able to help kind of identify appropriate clinicians that can help fill out this form. And also the clinical team report must be done even if a guardianship is established. A clinical team report will be done later on if there's a challenge to that guardianship at some point. For example, if there's a petition to limit it, if the person's capacity changes, and they or their attorney file a motion to limit this guardianship or even to terminate it, the clinical team report will have to be done. The next form is the medical certificate, and this is going to be completed for anyone with a disability that does not have an intellectual disability. It's kind of a one or the other type of deal. And as you can see on the slide, this must be dated within 30 days of filing the petition. But the examination must occur within 30 days prior to the hearing. So this might mean that the medical certificate has to be renewed. Hearings can be delayed for all sorts of reasons. So if enough time goes by and the hearing hasn't occurred, an updated medical certificate might be necessary. And unlike a clinical team report, the medical certificate just needs one professional essentially to fill out. This can be a physician, a licensed psychologist, a certified psychiatric nurse,
Tell me what's going on.
nurse
This stuff.
practitioner. It is unlike the clinical team report that requires all of those professionals' input. Um, But it is similar in that whoever is filling it out is encouraged to consult with other professionals, whether that's, a PCP or a regular psychologist who knows the person, knows their history and their background. They are encouraged to consult with this person, in order to better have, a complete idea of this person's capabilities. And again, similar to the clinical team report, it will ask for a description of the person's diagnoses, their prognosis for improvement in the next 90 days. That is something that the judge is going to want to know. Is this person's condition, static, or is it are they expected to kind of gain competencies or maybe lose them over the next 90 days? It will look for information about the person's current medications, impairment in their memory, cognitive functioning, psychiatric functioning, and how those impairments, this is important, impact their ability to receive and evaluate information. It also takes into account the person's values and their preferences. There's a section on it that asks the clinician to describe what those preferences are, any social networks that they already have in place, and then to give some recommendations for, treatment and perhaps the level of care that this person may need going forward, and also, again, recommendations for their attendance at the hearing itself. So again, as we've already touched on, the role of the guardian, essentially, once a guardian is established, is to make decisions about the person's support networks, their education, their health, and their safety. But as Hillary mentioned, Massachusetts law does stress that the person exerting control only when needed. In fact, guardians under Massachusetts law do have a responsibility to take the person's desires and their personal values into consideration. So, even with a plenary guardianship, sometimes, we give an example of, parents or guardians wanting their adult, children to dress a certain way. Well, I mean, they can have input if it's 30 degrees out and the person wants to wear shorts. That might be a situation where health or safety is at risk, right? And they'll be able to kind of have, this basis to kind of dictate what they wear. But if it's kind of a difference between wanting their adult daughter to wear dresses or skirts and the weather is appropriate, they don't really have a say in that. Because the person should be able to maintain as much control over their lives as long as their health and safety are being taken care of, as possible. And the guardian is encouraged, obviously, to participate, to encourage the individual to participate in decisions and also to work to regain competence. I mean, especially if their condition is, flexible and some of these skills might still be learned. The guardian does have a responsibility to kind of help that person get there and to gain as much competence as possible. And one other thing we like to mention here is that guardians do have immunity, from personal liability from the person under guardianship if they, do make any big expenses or act in a certain way, that may perhaps have legal ramifications. The guardian is protected against those. Usually those situations can be rare, but they do have immunity from personal liability for the protected person's acts. So in terms of reporting responsibilities, once a guardianship is established, they have reporting responsibilities to the court 60 days from the appointment of the guardianship. And then, annually after that, they have to kind of submit a, annual report that includes information about the protected person's condition, their mental condition, physical condition, and social condition, where they're living, what their living arrangement is, any services that they're receiving. The judge will want to know what contact the guardian has had with them recently, how often they've checked in with them. Usually this is more frequently if it's family member than if it's a professional guardian. If they're institutionalized, if they're in a facility, whether that living arrangement is still appropriate and should continue, what plans are for future care, and recommendation on need for guardianship. And this reporting responsibility also comes into play if the individual's condition changes significantly, if they significantly lose capacity or if they've gained, skills that could make them more competent to make their own decisions. Again, protections for the individual who is subject to guardianship. They do have a right to counsel. If someone on their behalf requests counsel, or if the court determines that they may be inadequately protected, many times the court will appoint counsel. Um, but the judge does have to affirmatively think that this person needs an attorney, or somebody must request it. So it's a little bit different from a criminal case where one is just automatically appointed all the time. Um, and they also do have the right to be present at the hearing. Again, a lot of times, if on the clinical team report, or the medical certificate, it's recommended that they don't attend, whether that's, because of sensory issues or issues in, being in a new situation, talking to people they don't know if that would really dysregulate the person. And it's recommended that they should not attend. A lot of times, judges will kind of agree to waive their appearance at a court hearing. But they do have the right to be present at the hearing. So as we've already noted a couple times, even when a guardianship is established, that guardian's power is not unlimited. And it's important to understand here that a guardian can't, even whether it's a limited or a plenary guardianship, when that's established, there are still procedures that have to be followed if extraordinary medical treatment comes into play, or we're thinking about potentially institutionalizing a person. So, what is considered extraordinary treatment decisions? So these are going to be treatment decisions that are not kind of customary and usual or standard medical decisions. For example, things that might come into play are considerations around sterilization or getting an abortion. I think some of the most frequent extraordinary treatment decisions that a lot of people might be familiar with are situations involving getting a Rogers order. Rogers is the case that kind of established the need for this extrajudicial approval. And it comes into play when a guardian is seeking to um, essentially give approval for somebody to be treated with antipsychotic medication. These medications are very, very strong. There is, or historically has been, kind of a high risk of abuse in giving these medications to people, and there's a potential for pretty serious side effects. So because these drugs are so strong and could potentially, have such severe consequences, there is a whole extra kind of component to a guardianship petition that has to be done if the guardian is also seeking permission to consent to treatment with antipsychotic medication. And in that case, the person subject to guardianship will be appointed counsel. They will be appointed Rogers counsel, and that counsel will consult with the person. Sometimes it's uncontested. Sometimes the person, it depends. It's very case specific, but sometimes the person can understand what the medication is, what it's for. Sometimes they've been on it, for a long time. Sometimes they've been on it before they turn 18. And this is just kind of keeping them on a treatment that they've been on that's been working for them. And this person, trusts whoever is petitioning for guardianship. They trust their treatment plan and their doctor. They don't really have side effects. They don't mind being on it. But sometimes people don't want to be on this medication and they have very valid reasons. And so that person's counsel will then, advocate in court. Either they can contest it or they can uncontest it. If the person does not want treatment with antipsychotic medication, if they're kind of fighting the Rogers, a lot of times their counsel will get their own independent medical evaluation, similar to the clinical team report or medical certificate, the information that's elicited on those. The Rogers Council will have their own independent medical evaluation, and they will have that doctor kind of write up their own opinion regarding all of those elements, the competency, what their opinion is on whether or not this person, needs these drugs. But it is very, very case specific. So we just wanted to kind of highlight here that even if a guardianship is established, there are still kind of hoops you have to jump through in order to be able to make extraordinary treatment decisions for a person. All right, let's see. So in considering whether or not to establish a guardianship, the standard that the judge looks to is not contrary to, I think, what a lot of people hear about. It's not the best interest of the person. The judge is not here to impose their opinion on what they think the best interests are of this person. They do what's called a substituted judgment analysis. And in doing so, the judge tries to consider what this person um, would what position this person would take were they competent. So they look to if this person were competent, would they consent to this treatment? So again, when we're looking at potentially a Rogers order and treatment with antipsychotic medication, the judge tries to look at would this person take this medication if they were competent to make that decision? And factors that they look to in deciding this are the extent of the side effects, which is a very obviously important consideration in determining whether or not to take any treatment. The probability that those side effects will occur based on, the dosage proposed, the frequency, the treatment plan. Um, and then they look to whether or not this individual has ever expressed any preferences regarding treatment. Have they ever, do they have any expressed, goals in treatment, or have they ever expressed, side effects or reasons why they would take this medication or they haven't? Um, they'll look at the prognosis, in addition to side effects, they'll look at the prognosis if this medication is given rather than if it's not. And they'll also consider whether the person has any religious beliefs that would impact their taking of this medication and any impacts on the individual's family.
Okay, thanks, Laura. We are gonna jump if my slides would advance. Oops, sorry. There we go. So just to quickly kind of tie up, Laura talked quite a bit about guardianship, what is kind of the standard guardianship that should be limited as much as possible, right? And when it's a situation that it can't be limited, the language you'll hear often is like the person's under full guardianship or the person is under a plenary guardianship. I don't know. Plenary is just the legal word that's used often to be describing it. And then when Laura was going through the kind of extraordinary treatment where you just need to go the extra step of getting court approval and having, clinical basis or whatever for this extra step of court approval. That's where that substituted judgment standard comes in, but in a, quote unquote, like normal guardianship, I don't know, the non-extraordinary decisions, like the run-of-the-mill guardianship, that is the best interest standard. It's the substituted judgment comes into play when we're, frankly, the most typical one, as Laura said, is when we're talking about antipsychotic medications, and the judge will use this substituted judgment standard that Laura described. Just wanted to tie that up. Maybe everybody got it, but it can be kind of confusing, legally dense, all of that. And we just want, no one has to memorize all of this. We just want you to have an understanding of the process and what to expect if you are going to be going through this process, if you're going to be talking to a family about what this process might look like, just to kind of be able to give you that information. So we are basically done. I think we did pretty well. It's 11. So we have just a couple more things to talk about, and then we'll open it up to questions and comments from folks. But before we do that, just a couple kind of common issues that tend to come up and people almost always ask about is kind of like timelines, right? So if we're talking about somebody who is not yet 18, what are the timelines for alternatives guardianship to get those into place or a guardianship into place? If somebody obviously is over 18 already, the timelines are really kind of less vital. And if you have specific questions about somebody that's over 18 already, we're happy to answer that. But generally speaking, for alternatives to guardianship, right, if we're talking about like healthcare proxy, durable power of attorney, representative payee, there's really, like, aside from educating, the person, education ahead of time, you really can't do anything until the person is 18, right? So, because they have to execute the healthcare proxy, they have to sign the durable power of attorney, they have to do all of that, and they can't do that until they're 18. So that's that. From a guardianship standpoint, right, like, technically it cannot go into effect until somebody is 18. Different probate courts move faster than others, some move slower than others. It really depends on your local probate court, how quickly that whole process will go and how fast you get the hearing to go in front of the judge to, argue for guardianship or argue for, limited guardianship, and all of that, and to discuss that. But what you should absolutely be doing ahead of time is, of course, considering what this whole process that we walked through is like. What are the possible areas that somebody needs assistance, and what is available to meet those needs? Are there alternatives available to meet those needs? Can it be limited guardianship in any way if guardianship is necessary? So if we're coming down to a guardianship of some kind is going to be necessary, as Laura noted, the clinical team report, the medical certificate, they do have specific timelines around them. And you'll get a copy of the slides so that you'll see again the timelines. But the clinical team report in particular, because it does require those three specific clinicians, a physician, a psychologist, and the social worker. You need to, whether it's like at 17 or something, if you're really thinking guardianship is in the future, you should be starting to explore those options. And that is an area where the transition specialists in school, like, what's available in your community. And it's not necessarily advocating for guardianship, to give somebody information. Like, we just want information so that people can be educated about their choices. And it can be really hard to locate a psychologist and a social worker for this if there's not people available through the school, or if there's not already those people in the community in the person's life. And that we certainly have a lot of instances where there's people scrambling to try to find a psychologist or a social worker to help with this. And it's more than just paperwork, right? These are the clinicians that are, like, literally doing the assessment of the person with the intellectual disability to determine if they really do feel, from a clinical standpoint, that a guardianship of any kind would be necessary for this individual. So whatever folks can do at the local level to have information on what's available in the community, if this is, something that that an individual may be needing to pursue, we just encourage you to try to share information and have information available for people. Sorry, that was my little soapbox of know what's available in your community. And then just from a PCA and AFC, just a real, quickly, many of you may already know this, that you cannot be a guardian and also be somebody's paid, PCA or adult family care or adult foster care provider. You can't do both. That is what the law presently is in Massachusetts. So if there is perhaps a situation where there are two active, parents in a situation that are either, together or get along very well, sometimes families will have one serve as the guardian and one, if a guardianship is necessary, and one can work as a PCA or be the adult family care or foster care provider, so that you can be paid for a lot of the care that you're providing for somebody who might need that. But certainly not everybody has, two parents readily available to do that. There could be really messy divorce, parents aren't together, any of a zillion situations, right, of why that would be challenging to have one as a guardian and one not. So we very much understand that. And if you are feeling strongly about that, you can certainly call your legislators about that, because again, there is a bill pending in the legislature this legislative session that would allow family members and spouses in a situation where it's a person with a disability who's married, that it would allow spouses or people who are serving as guardians to also be a PCA. But that is not the law yet. If you feel strongly about it, call your legislators and urge that it be passed, because this can be a very challenging situation for single parents and whatnot. So, okay, that is it. Wanted to just address some of those common issues. These are just some resources in addition to the ones that we provided earlier about that were specific to supported decision making. These resources are one, is just our resource that is our own, that really kind of summarizes a lot of what we talked about today. That's the DLC handout. The links to the probate court forms sounds like a really boring link, but I do have to say it is a boring link, but it actually has a lot of really great information. I would absolutely criticize court systems in general for being disorganized and not like user friendly. But I will say this link, they do have a lot of information on both, what guardianship is, how do you, how instructions for how to complete the medical certificate. Like there is quite a bit of information on it, and there are the blank templates for the different forms that one would need. So you can go there and see those too. I find it very helpful. And then just because we can say, oh, a guardianship should be, if there's a guardianship needed, it should be as limited as possible. That's easy to say, but it's kind of like, okay, what does that mean? Like, what are some areas that my person can retain rights and responsibilities? Because maybe it's a situation where they really do need a guardian for medical decisions and for these like really big, major decisions, that it's somebody that has very involved cognitive, intellectual disabilities, and they really do. But there are areas that they might be able to retain rights still. And this link is not meant to be an exhaustive list of all of those, but it is a very long list of things just to kind of for you to be thinking about of, are these possible areas that a guardianship could be limited in my person, or a person that you're working with their family or whatever, where they could retain some of those rights and responsibilities. Maybe it's choosing where to live, maybe there's a lot of examples there. So those are those resources, and we are open for business for questions. And thank you so much for having us, and we hope we can answer them as best we can.
Thank you both. Yeah, no, that's a lot of information, and we definitely have a bunch of questions coming in. So if anybody has any questions, just feel free to type them in the chat. If you do have a question that's too difficult to type in the chat, or you can't type from your phone or whatever, just raise your hand in Zoom and I'll call on you to unmute and talk. But since you were just talking about the clinical team reports, there are a few questions around that. So just questions about, are school psychologist reports sufficient for that? Can a school psychologist sign the CTR? Are there pro bono physicians or other people that will work with low-income families to get those signatures taken care of? Just kind of like, where do families go if they don't have those people already in their lives, and who can sign those?
Sure. So we'll start with kind of the low-hanging fruit, I think, which is the physician. That's the one I think for most people it presents the least challenges, because it can be the person's pediatrician, primary care doctor. That's it just has to be somebody that's an MD, that medical doctor that is somehow knowledgeable of this person. So it could be a primary care doctor. It also, it could be a psychiatrist in situations where there's a psychiatrist involved, right? Because a psychiatrist, they are a medical doctor. So that, I think the physician one is the one that people hopefully can find and already has in their lives. So obviously the most common one is somebody's primary care doctor that they use for this. To answer the questions about the school psychologist or any psychologist. So they have to be a licensed psychologist. There's more information about what that would be. Some of these court forms kind of talks about what the person's qualifications have to be. So it really depends in a lot of situations about whether that school psychologist has the appropriate credentials. And I would just encourage you to go to the website that has the probate forms and has information on the clinical team report. There are instructions for the clinicians who would be completing the report. So I would encourage you to go that to be able to figure out if that school psychologist has the appropriate credentials. Also, there are some school districts that just don't want their school psychologists to be involved, I guess. So they don't want them to do it, even if they, from a professional like credentialing standpoint, could. I think that's unfortunate, but it is what it is. So, what resources are available? So when you're asking, are there, for example, clinicians that will do this pro bono for low-income folks? Perhaps this is going to be very local community specific. And so I don't know, Laura and I don't know what specific resources are available in Lawrence to support folks. So I would encourage, whether it's transition specialists or family support, folks, that's a research project, right? Is to be reaching out to folks in your local community to identify resources. Maybe there's, I know in some situations that I worked with families in kind of in the Boston, in certain neighborhoods of Boston, there were community health clinics that had folks that were able to do this, psychologists and social workers. So it might be a place. So I don't know. I hope that's somewhat helpful for folks.
Thanks. Yeah. There's a couple other questions around someone who already has guardianship, and if they did guardianship, say 15 years ago, when there wasn't as much push for supported decision making, can they go back and kind of revoke guardianship and do supported decision making instead, or how does that work if people want to kind of change course with that?
So if there's already a guardianship in place for whatever reasons there are, and sometimes it can be that, nobody knew there were other options available, or perhaps the person seemed to present clinically, there was clinical support that they needed a guardianship at that time, but they've matured, they've gained skills, whatever it is, right? There's a lot of reasons why we should be re-looking at guardianships to see if there's other options that could meet the person's need. So here's the thing, it's more difficult to undo a guardianship than to get one in place to begin with, which is why we started the whole presentation with let's think through all of the alternatives to guardianship and if there's going to be enough to meet somebody's needs. Because if you try it and it doesn't work out, obviously, again, we're not advocating you try something totally unsafe, but if you try something and it seems like, oh, this isn't really enough, you petition the court, you get your clinical support, and it's a fairly linear process in a certain way. If you're trying to undo a guardianship, it's certainly not impossible to do, but you do need to, if it's a person with an intellectual disability, you do have to get another clinical team report. So you have to go back, get that done. That has to be done within 180 days of your hearing and this. So you have to get another clinical team report, and you have to essentially fill out the appropriate court forms that would petition to either limit or terminate the guardianship. And you will have to go back to court for a hearing regarding the same. But again, it's obviously not impossible to do. It can happen very much. But there's process. You do have to go back to court for it. You do have to get clinical support that the person's needs can be met in other ways, or they just have regained competence. So obviously they don't need a guardianship anymore, right? But typically that's going to require a fair amount of clinical support.
All right, thank you. And guardianship state to state, if somebody gets guardianship in Massachusetts and they move out of state, do they need to go to court again, or what happens with that?
Yeah, so sometimes yes, sometimes no. So there's and Laura, chime in on this if you have any more information. So I'm more familiar with if somebody moves into state with an out-of-state guardianship. So again, on that wonderful court website, so it's like the Uniform Guardianship Act. Is that what it's the official name? Uniform Guardianship something. It's very clear on that page, and there's information on there about how like essentially how a guardianship that was done in New Jersey or whatever, and the family moves to Massachusetts, how to get that honored in Massachusetts, so to speak. I have not personally handled that type of a situation, so I don't know, Laura, if you have, but the answer really is like sometimes you will need to do a new one and sometimes you won't. It depends on the state that you're moving to and or the state that the guardianship originated. So it's a really kind of case specific determination is my best of my knowledge on that. Laura?
Yeah, no, I agree. It really is, every state has its own laws. So I would just recommend that, you check the individual laws in the state that you're either moving to or moving from, and, maybe consult with counsel in that state. But it's just hard to answer because it is really state specific.
Yeah.
All right. And if someone has a supported decision-making agreement already in place, how is that enforced? Just for example, in a healthcare context, does a doctor require them to check with their guardian before taking a new medication, that kind of thing? How does that work?
Okay, so supported decision making, there certainly somebody under guardianship could also be utilizing supported decision making in a sense. However, typically we're pushing, if it's appropriate for somebody, that they would not be under guardianship at all, right? If they are able to be making decisions with support, that they don't need a guardian, meaning somebody coming in and making decisions for them. They just need support, education, whatnot, to be able to make their own choices. So in that case, so sure, we take the medical context, right? And at the end of the day, the question is like whether or in the bank, dealing with finances, is that third party going to honor the supported decision making agreement? And that's the biggest challenge. And it's also part of why getting the getting legislation on the books in Massachusetts is actually quite helpful, would be very helpful, because in the proposed legislation, as it is in many other states, there's language in there about how essentially like that doctor or whomever, like they're concerned about liability, that they're not liable for, there's language in the statute that kind of would speak to things around liability that in theory should be helping to make that third party more comfortable, if that is their major concern. This is a ongoing societal education thing, right? I mean, the assumption unfortunately across the board often is that everybody with an intellectual disability needs guardianship, right? And that's not accurate. Some do, some don't. So it's an education thing. The doctor cannot say right then and there, like, I'm only, you have to have a guardian. But I mean, certainly there are situations that can get a little bit messy, if we're talking about a major surgery or medical decision or major medication change. There are situations, yes, where a hospital has taken the stance that no, like we're going to go to court because we think that this person actually needs a guardian and that they're not competent to make this choice, right? So that stinks if the person really is capable, but that's also not a slam dunk guarantee, right? That just means they're going to court to ask a judge to decide, and it's a headache, it's a lot of process, and it's can be expensive and time demanding, but the hospital or whomever doesn't in and of themselves get to decide, right? They just get to go, they can petition the court and say, we don't think this person is competent. And they have to have clinical support for that. I know that's probably not a really satisfying answer, but whether it's supported decision making or any of the other alternatives we talked about, the biggest challenge in all of this is the third party.
Excuse me, sorry, that was my
Yeah.
question. My
Yeah.
question is really, does a doctor say to the person with the shared decision making, like with the person who's being supported, do they say, did you check with your supportive decision making person before there's like a decision
Oh,
making? That's my question.
oh, I'm sorry.
It's okay.
So did I just talk for 5 minutes and not answer
It's
your
okay. I mean, you provided
Okay.
good information anyway, but like, I'm wondering like, how is it enforced? Like, does someone say like, okay, well, did you talk to your person already?
Well, first of all, I would start with sharing somebody. So if I'm the person with the disability that has a supported decision making agreement, and I have my whatever supporters, and say my mom's my supporter that I've designated for medical stuff, right?
Yeah.
My doctor doesn't automatically know that. Why does my doctor know that I have my doctor doesn't, why is that in a sense any of your doctor's business unless it comes up that there's like I don't know, does Hillary, like, this is kind of a big choice, are you really understanding? Then there should be a very open dialogue of, yes, I've consulted, this, that, the other, but
Okay.
the doctor, this third party, like, they're not a party to the supported decision
I
making
see.
agreement, right?
Okay. I wasn't sure about that. Okay.
Yeah,
Got
but
it.
many people have wonderful relationships with their doctors, their longtime treating clinicians, right? And this might be it might be very appropriate in that situation to be sharing, what supports I have put in place for me to help me now that I'm adult to be as independent as possible and make these choices, right? Like if you have
Got it.
wonderful relationships, it's probably a wonderful thing to be sharing that information so that everybody's, can support me as best they can, right?
Thank you.
Sure.
And in situations like that where you're potentially worried about the person's ability to make decisions about, medications or whatnot, would it be more appropriate to have a healthcare proxy in that situation?
Well, a healthcare proxy is only making the decisions if the person is incapacitated.
Ah, okay, I see.
So if there are, if there are real concerns about somebody's capacity to be making medical decisions, then it's probably time to talk to a clinician about that, and that's experienced, right? And this type of capacity competency assessment. And if there are real concerns, then maybe this is a situation where guardianship is part of the discussion, and maybe it's limited to medical decision making if that's really the area that this person is I don't know, they're diabetic, they have a gazillion other medical complexities, and it's difficult for anybody to manage. And we add in perhaps a mild intellectual disability on top of that, or something like that, or a moderate intellectual disability, whatever it is, like we add that on top. Maybe we are talking about, is this a situation where we need to kind of, again, look at our options and go down the road, right? In the same way that, like, look, in the special ed context, substantially separate classrooms still exist. Out of district placements still exist. It's just, it's what can we do? Are there other options prior to that? It's not saying like you should never go in these other areas.
All right. One or two more questions. Someone was asking for a little bit more clarification around the difference between conservatorship and guardianship. You just kind of go through that.
Sure. Laura, do you want to take it or do you want me to? Okay. I just don't need to want to monopolize.
I mean, you can take it.
Okay.
I mean, basically, in a nutshell, it's conservatorship is, the power to make decisions over somebody's estate and to manage their money if they have more assets than just Social Security. If their only income is Social Security, then representative payee is the more appropriate option to help manage that. But if they have several different, properties or other assets, a lot of money in their bank account, the conservator would help kind of manage their assets and their property, as opposed to kind of like their health decisions, their self-care decisions, just kind of like their day-to-day decisions. But Hillary, you can kind of expand on that a little bit if you have more.
Yeah. So, I mean, you can just think of it as like guardianship of the estate, right? Guardian, it's just not the personal affairs of some personal being, it's the other parts. So if somebody cannot make informed decisions about various financial related things, then perhaps we're talking about a conservatorship if there's other assets that we're talking about. Now, a lot of times we're talking about if somebody has really very, very significant intellectual developmental disabilities, we might be talking about a situation where somebody is under guardianship and there is a rep payee in place to deal with the SSI, SSDI, whatever. And then there's a special needs trust perhaps put into place. And as you know, I'm not here to talk about estate planning, but from a special needs trust standpoint, you don't have to be a gazillionaire to set up a special needs trust. Granted, it can take a little money to set one up, which is annoying, but most special needs trusts that are established are unfunded, meaning there's no money in them, but they are funded perhaps with parents' life insurance, things of that nature. So there are ways essentially to provide money, assets to your loved one or for somebody to receive those. And they're protected from government, it doesn't impact their government benefits or anything of that nature. So it's not like, oh, do I need a conservatorship in place if, grandma passes away because she wants to give, 10 grand to my kid, right? If you set up a special needs trust, the 10 grand can go in the special needs trust. Or there's, just different estate planning ways to manage that. That means you don't have to have a conservatorship in place. I don't know if that just confused things more, but just a lot of times a conservatorship is not needed. I probably just confused everybody more. Sorry.
So I think we had some questions that were kind of similar. So I think I've kind of covered the overall questions that have come through in the chat. If anybody has one final question, feel free to pipe in now, but I think we've covered all the questions in the chat. So thank you very much, guys. All right, I don't see any raised hands, so.
Oh, we might have one more.
Oh, one more. For an individual with autism and no intellectual disability, would they need a clinical team report or an MC?
Technically, the clinical team report is intellectual disability only, intellectual disability defined as an IQ of approximately 70 or below with substantial impairments in adaptive functioning as well, right? So if there is no intellectual disability, you do not use the CTR. So you use a medical certificate. Now, do people make mistakes with that all the time? So, it's okay. But the CTR is only for intellectual disability.
All right.
And if people have questions or things that they come up with, after the fact, I do that all the time, right? It's like I had my window and I blew it, and now I have all these questions. If Matt and the folks are okay with kind of continue, fielding any follow-up questions, they can certainly funnel them back to Laura and I, and we can address them as best we can, because you took the time to attend this. So the least we could do is try to, answer a question that clarifies something that we were talking about.
Great, thank you. And I'll put our group email address in the chat. It's community resource center at any-arc.org. So if you send an email there, it will come to our whole team, and one of us can field, kind of answering that or getting to you to someone who can answer it.
Perfect.
All righty. Thanks again, Hillary and Laura, for your expertise from today, and Carrie for facilitating our Q&A session. Following today's session, we will be sending an email with our presentation slides. We create a resource guide and event guide that we'll be sharing with you as well on the topic that we discussed today. And all of these materials can also be found on eCommunity Connections, which is our dedicated website to sharing community resources and events throughout the Northeast region. And we'll also be, because we recorded today's session, we will make sure to connect that recorded session to that follow-up email. And we wouldn't be able to run the Northeast Transition Collaborative Network without our amazing staff on the Community Resource Center team. Our team consists of 5 community resource specialists who are embedded in each area office in the Northeast region. So we would like to thank Carrie Neenan, Chris Marchese, Mary Rothstein, Holly Keene, and Amy Richards for all the help and support for preparing this today. Our next session will be our in-person professional development for educators. This is on Tuesday, March 17th at Salem State University. Our topic will be on empowering student voice, practical strategies for transition IEPs. And this is a full day professional development from 8:30 a.m. to 3:30 p.m. We provide a light breakfast and a lunch as well. To register and purchase your ticket for this event, please scan the QR code on the screen. And we'll also provide a flyer for that event in our post-session email. And something that we wanted to start doing was providing our future sessions. We went ahead, planned out some of our topics. So in April, we'll be doing transition-focused employment pathways for our monthly webinar. In May, we'll be doing another in-person professional development for educators on self-advocacy. In June, we'll be doing post-secondary options and non-traditional paths. And in July, we'll be doing financial and benefits planning. So those will be sent out. A registration for those will be released about 1 month before the date is offered. So we'll send those out as soon as we have them. And for those who are looking to claim PDP for today's session, you'll receive a participant survey by email and followed by a certificate of attendance. And once completed, we'll be sending you a 3-month and 6-month assessment survey required to finalize your PDP hours. We want to thank everyone for joining us today. If you have any questions or feedback, feel free to reach out to us or Disability Law Center. And we look forward to seeing you at our next session. Thanks, everyone.